Greetings to everyone. It's 7 minutes past the hour, and we need to start. My name is Samuel Mbugwa, and I'm the one who will be handling the unit, Trust and Executorship Law and Accounting. Today, I want us to introduce Executorship Law. And Executorship Law is the law of succession. It is that body of the statute law that talks of the law of succession. In our constitution, it is a chapter 160 of our laws. The Law of Succession Act is Cap 160. Our constitution is organic, therefore the law keeps on being revised. So the latest edition is 2012. And I'll urge everyone to go through the Law of Succession Act, because a lot of things that we are going to do in this particular class will be enshrined in our constitution. We will be borrowing here and there for purposes of precedent or comparison, but mostly we'll be dwelling with our Cap 160. So executorship is that body of statute law or case law that concerns the management of the estate of a deceased person. A deceased person may either die having written a will or without a will. So when a deceased person has written a will, we say that they died testate. What is a will, or what is a valid will? We will say a will, we say a will is the, when a person or the living person documents how he wants his property to be shared amongst the various beneficiaries or heirs. When he dies, we say that he has done a valid will. So we'll say by definition, a will is a legal declaration by a person of his wishes and intention regarding the disposition of his property after his death. So this will be made and get executed according to the provisions of the Law of Succession Act, Cap 160 of the Constitution of Kenya. You realize that most of the parts, or nearly all, will be using he. Our law is borrowed from the United Kingdom Constitution, and they apply a masculine person. So where you see me dominating with he, kindly note that it applies equally to women, whether they are married or otherwise. Now, so we've agreed that a testate is a situation where the deceased person has documented or left a will disposing or showing how their property will be disposed when they die. In some cases, you may be having the property, you may be even a billionaire, and I'll be giving examples, but you didn't document how your property will trickle down to your beneficiaries. In this case, we'll say you died intestate. So intestate is a situation where the deceased did not leave a valid will, and the will does not dispose their property. There could be a will which doesn't dispose of their property. Let me give examples. Garishon Kirema was one of the Kitsuru billionaires or tycoons. I remember when he died in a hospital in South Africa, some few months later after his burial, the family, the widows, the children were fighting in the court because he didn't leave a valid will. I remember also Kenneth Matiba had a will, but there was a problem because he had not, I remember there was a property worth some 732 million or thereabout that he had not disposed in the will. Again, this brought a lot of wrangles between the children and the mother, and they were seeking intervention of the court to interpret who is supposed to take control of the property. Now, these cases sometimes become so gross. You can remember the case of Bob Cohen, who was found in the what do you call it? In the septic tank. And the court could not confirm that the wife, Wairimo, was behind the murder. So there was a challenge in, again, taking control of his worth, his property worth of millions. So these are some of the cases that I'm trying to give where you have left. We had even Kerema, the former interior minister in the Moi government. You remember, again, he left, he was a billionaire, he left a lot of wealth, but the family was again left struggling. So these are the cases. But you've also had good examples of people who have died tested. A good example is the late Nicholas B. Watt, the Toto man. He left a very good will. Recently, we had Kerema. Not Kerema, we had, what do we call him? Recently, we had this man, Chris Kirubi. Chris Kirubi also left a will, and it was very welcome. You can see there is an interjection. Lucas Minor, put your mic on and talk. Lucas Minor, put your mic on. I will encourage people to be talking in this class. Lucas, can you hear me? Cannot hear you. Lucas, I cannot hear you. I was trying to establish whether you are the one who has a problem or it is me. And could be you are the one who has a problem. No network is two-way. Otieno Akoth. Otieno, put your mic on. Guys, let's talk.
Yes.
You can hear me clearly.
Yes.
That could be Lucas has a problem. So Lucas, kindly check your network, because Otieno can hear me. So I go on. I was giving an example of, I've said we are not short of good examples. I've said there are some people who have documented their valid will so well. A good example is Nicholas B. Watt. He died a testator. He documented his valid will. Cases of like Chris Kirubi, the Toto man. We had the likes of Saitoti, although we had a situation where a family in Subukia was claiming that the son that the family had adopted was their son. Well, I'm trying to say the reason why we need to have a valid will, on demise, especially in the traditional African society, family wrangles are a commonplace across the divide, not only in Africa, even in the most developed worlds. So what the valid will tends to do is to try and give a guideline and try to limit the cases of these wrangles and help the beneficiaries, or rather the heirs, to share the wealth of the deceased person quietly from the public eye, and let the people who left the wealth to rest peacefully. Yeah. So we'll be looking at those scenarios. I've said that we are guided by Chapter 160 of the Constitution of Kenya, the Law of Succession Act. So I've urged everyone to go ahead and have a look at it. It is in the Google. So this information is public knowledge. Now we come back. I was just trying to lay a foundation of what we'll be doing for the rest of the semester. So we'll be trying to see in cases where the valid will has demonstrated that the property is registered. For example, the Jomo Kenyatta wealth. Again, another good example. All the wealth of the Jomo Kenyatta family is kept in a trust. And that's why the unit is Trust and Executorship Law. But I've started with executorship. So we'll be coming to that, where the deceased person helped or opened a trust and disposed the property with the trust, and therefore the trust will be responsible for executing the mandate, or giving the beneficiaries what belongs to them. We come back now. So since the vast majority of people in Kenya die intestate, we can all agree, not most people want to talk about death, especially Africans. It's like when you do a will, it's like you are foreseeing your death. So not many people will do that. And that's why we are caught in the confusion. But in Kenya, I want us to put perspective of the intestacy situation, or where someone died and didn't leave a will. The Constitution talks of how the property of this particular person who didn't do a will is supposed to be shared. But the agricultural land, this is what I've indicated here, agricultural land, crop, and livestock, in most cases of Kenya, are not covered in this chapter, or the Cap 160. And normally this will fall under what we call the customary law. And customary law in Kenya is so powerful, such that it overrides the constitutional law. So that you know, for instance, the customary law does not allow people to divorce. Well, the Constitution allows people to separate and also divorce, but there is nowhere in the provisions of the customary law where people are allowed to divorce. Actually, the wazees, the elders, because they are the custodians of the customary law, they'll make sure that the marriage works, even if it is to force it. So you can see how powerful the customary law is. So I'll be talking of the distribution in these 4 scenarios. The first one is the situation where the spouse, the deceased, leaves no spouse and no children, so they died a bachelor. There are situations where the intestate leaves no spouse, but they are children. Either they had separated, or the spouse predeceased them, or otherwise. The third scenario is the situation where the deceased person leaves one surviving spouse, but there are no children. And then the 4th scenario is where the intestate leaves one spouse and children, or they are in a situation of a polygamous family. Again, our Constitution allows for polygamy. So for those, for the communities that practice polygamy, like the Muslims, which is in the Sharia law, we are going to see how the property is supposed to trickle down to the beneficiaries. Well, the first case, you die, you didn't have a spouse, and there are no children. So if this happens, your property will be shared as follows. It will devolve to the father. If your father is dead, it goes to the mother. If the mother is dead, we go to your blood brothers, so brothers and sisters, and any child or children of the deceased brothers and sisters. For instance, if you had brothers, let's say 3, A, B, and C, but A died, we are going to look at the children of A. If they are not there, we go to the half brothers and half sisters. If again they are not there, we go to the other relatives who are in the nearest degree of consanguinity. When I say consanguinity, is the blood relation. So we are looking at the nearest after the uncles. And if they are not there, again, we take this property to the government, the consolidated fund of the government, and we declare it as unclaimed asset. So we will not lose the property because you died intestate. The law has provided how it's supposed to be shared. And I have an example there. A dies intestate, he never married. His father and brother have predeceased him. A is survived by his brothers C and D, and sisters E and F. His brothers B predeceased him, but left a wife K and children L and M. His net estate worth 3 million. How will it be shared? So we've indicated. So you can see we have A who didn't have a will. The father and the brother had predeceased them. So A had predeceased him. So A is survived by brothers C and D and sisters E and F. So these are the ones who are closer. His brother B predeceased him, but had children, but left a wife K and children L and M. The net estate is 3 million. How do you think we are going to share these 3 million? Guys, this is a class, so I expect participation. Lucas Minor, are you logged in 2 gadgets? That's the reason why you are having the problem. If you have 2 gadgets, of course, one will be giving the other one the echo. So log in with the most preferable gadget for your own good. Lucas. How are we going to share? So look, we have these people. So we have C and D. These are the surviving brothers. We have E and F. These are the sisters. B is dead. Now the confusion comes in where we have the wife and children. But if you look at the law, where the provision is, wife is not provided for. So the property will trickle down to C, D, E, F, and LM. You're going to take the 3 million, divide by 6, each will get 600. So kindly note that the wife will not get anything, but the children will each get 500, 500. Well, I've said we are driving our mandate from the revised chapter 160 of the Law of Constitution of Kenya. And in 2012, section 39 reviewed, because it is like the women were being jeopardized by this particular clause, but I've dealt in the old law. We still have a confusion, but I've dealt with the old law. So the wife will not get anything. Yeah. We go to the second situation. Intestate leaves no spouse, but their children. So the net estate will devolve to the surviving children, and this will be divided equally between all among them. So this one doesn't have a problem. But if there are children who haven't attained the majority years, in Kenya, majority years is 18 years. We are going to put everyone will share, but those who have not attained the majority years, we are going to put the wealth under the guardian or people who are taking care of them. We call them in legal term, the local parentis. So those students or those children who are either schooling or they've not attained the age of 18 years, we are going to share their wealth and keep it under the local parentis until they attain the age of 18. I have an example there. A dies intestate. His wife, Mrs. A, died some years ago. Mr. A is survived by his sons, B, who is 22 years, and C, who is 18 years. His daughter D is at school. She's not yet married. His net estate is 3 million. How will his property be divided? It will go to B, C, and D in equal measures. So 3 million divided by 3, each will get 1 million. However, D has not attained the age of 18. So as per the past stripes rule, this will be kept under the local parentis until they achieve the majority years, which is 18 years. I have another example there. Or if, let me bring the scenario, if a child of the deceased intestate predeceases him, but leaves his or her own children, or what we are calling issue. An issue in law is either children, grandchildren, people who are related to the person who is deceased. We call them an issue. The issue will take through the degrees of consanguinity in equal measure. Again, what was bequeathed to the predeceased person by the intestate. I have an example there. Mr. K dies intestate. His wife, Mrs. K, died 2 weeks before Mr. K. Mr. K's eldest son, M, died some years ago. M's children, P, Q, and R, are alive at the time of Mr. K's death. B, C, and D are Mr. K's other children. So Mr. K has died. His net estate is 3.6 million. How will it be shared? So we have B, C, and D. They're going to receive each 1/4. Of course, we expect even M will be shared. So we have four children, B, C, D, and M. Only that M predeceased Mr. K. So we are going to have B, C, and D, and M each taking 900,000. So we are going to have 3.6 divided by the 4 children. But because Mr. M is dead, but left children, these children are 3, P, Q, and R. We are going to share Mr. M's share with the 3 children. So each will get 300,000. Are we there? If you get confused, kindly talk. So if the intestate during his life, or by will, gave or settled any property on a child or grandchildren or house, that property shall be taken into account in determining the share of the intestate estate that will be accruing to the children or the grandchildren or the house. And I have an illustration there. I've shared this illustration in the photo because I want us to go through it. Are you able to see the illustration on your end? I will open Excel. That's why I'm asking you to go to the portal. I'll stop sharing and open an Excel so that we see how we are going to share this, being guided by the past stripes rule. Lucas. Otieno.
Yes.
Have you opened the portal? Kindly, guys, let us communicate. Let us not make this thing one end or monologue. Learning will take place if we contribute. Otieno, have you opened your portal?
I'm opening.
I'm sharing the Excel. Confirm. I have Excel on your end. I'm trying to share the equation on the Excel to try and solve your problem of opening it on your end. But the way it is behaving, is undo. Ratio. And I format this cell to wrap it. And there now. So the question is there. So Mr. K dies intestate. So we can just put this information. We have the sons. So we have the sons. Let me put the information here. The good thing, once the examiner asks you such a question, is to try and unpack the question. Mr. K dies intestate. His wife and eldest son J have predeceased him. So the wife is not there and J is not there, but J is a son. So let us kindly document that. Then, and his sons M and N. So we have another son M and we have another son N. We are breaking the information as it comes. During Mr. K's lifetime, he had made gift of 1 million to N. 1 million to N. N had been given 1 million, and N 1 million to N, and shillings 500 to B. K is survived by A and B. Mr. K is survived by A and B, the son and daughter of J. Yeah, so we have son and daughters here, A and B. Let me just write here, dead or deceased. But we have sons A and B, so that we don't forget, right? We have sons A and B. Let me put this information here. So that I use the first cell. We use the first cell to put the information. So this is how we'll do it. We have the net estate. The net estate is 5 million, right? I need another, let me put here the total. 5 million, that is 5M. So this 5M, we've been told that there was an advancement of 1 million. So I'll add the advancement of 1 million. I want to know the total that was shared because of the law. So the total is A and B. If you look here, A and B are sons of J. But those who really belongs to the 1 million was given to, so the total is 6 million. Let us first share the 6 million. The 6 million will be shared to the 3 sons in equal measures. So this will be 2 million, 2 million, 2 million, right? 2 million, 2 million, 2 million. But we had an advancement that was given to, we need to less, that was given to, is it M? It is to N. So we are going to subtract. Let's subtract 1 million. So this is how we are going to get the shares. We are going to get 2 million, 2 million, 1 million. So you can see now we are able to share the 5 million because 1 million had already been advanced to son N. Are we together? So that's how we are going to share. But there is another advancement that had been given to the son B, who is the son to J. So J is deceased. So I'll again come here and try to share J's way off. Our meeting will end in 10 minutes. Once it ends, just join using the same link, right? There was an advancement to B of 500. Let me just write there. Copy. To B. So this is J or 500,000. That is 0.5 M, right? So that we know what is being shared. So let me just write here to B. Be clear. This was to N, the son. So to B. So the total that is shareable here is 2.5 million. 2.5 million is what is shareable to A and B. So if I write them here, A and B, A and B, these are the sons. I'm going to share these 2.5 to A and B. So each will get 1.25, 1.25. Are we together, guys? But B had already been advanced. So I'm going to subtract the advancement to know what really went to him. So we are going to subtract 0.5. It is million, 0.5 million. And therefore, the share to the son will be, this is 1.25 million. This minus this is 0.75 million. Are we there? You see the way we have broken that question. It is easier for everyone to understand that Mr. K died intestate. The wife is also dead, and the son is also dead. But there are issues, A and B. So Mr. K had bequeathed to earn 1 million before he died. That's why we have subtracted the 1 million. And he had also bequeathed to the son B 0.5. So that's why we are deducting. So we assume that this forms part of the net estate. The reason why the law is coming in is to ensure that we have a level ground. No one will go home complaining like N was favored by my father, because these are the issues that bring about the wrangles, and we end up now getting cases of court cases, and these cases at times they are going to drag, and as it drags, it wastes away the estate that people are fighting for. So I'll go back. I'll stop sharing this. Going back to the note. So that's a situation where we had a situation where the deceased had bequeathed some of his estate to the beneficiaries when he was still alive. Later on, we'll be calling those cases inter vivos. Inter vivos is when you leave or when you share before you die. So the intestate, we are in the last scenario where the intestate leaves one surviving spouse, but there are no children. So this is how the wealth is supposed to be shared. First one, the personal and the household's effects, and they've been defined by law. These are clothing, articles of personal use, adornment, furniture, appliances, pictures, ornaments, food, drinks, utensils, and any other article that is found in the house. Whether it's used for decoration or associated with the matrimonial home will be left to the wife. There is no two way about it. All the households or the personal effects are left to the wife or the widow, but not any motor vehicle. So motor vehicle is not a household. Of course, cars don't live in the house, right? They are mobile. So, but not motor vehicle or any other thing connected with the business or the profession of the deceased. 2, the first 10,000 Kenyan shillings out of the residual of the net intestate estate will go to the widow, or 20% thereof, whichever is greater. So if the estate is more than 10,000, no, if the amount is more than 10,000, when we take 20%, we are going to take 20%. Let's say the net estate was 1 million. 20% of 1 million is 200,000. So we are going to take 200,000 and not 10,000. But where it is less than that, then you are going to take 10,000. And 3, a life interest in the whole of the remainder. If the surviving spouse is a widow, this life interest ceases upon her remarriage to any person. When the spouse dies or remarries if a widow, the property subject to the life interest devolve in order of A above. It will go to the father, father not alive, mother, mother not alive, uncles, or their children, not alive, relatives, not alive, go to the government. Are we there? The reason why the law is behaving like this in part 3 is to avoid the scenarios where people kill their spouses to take advantage of their estate and then they get married and start living another life. It happens. If you are married by a billionaire and this is not the person that you intended to have a life with, you know, these situations where people are getting sponsors. You know them, the sponsors. Baba or mamas, is 2-way. Whether you are widow or widower, you are not supposed to marry. If you marry, the assumption is you are doing this to take advantage of the estate of the deceased. That's why the law is behaving in that manner. Law is an ass. We go to scenario 4, where the intestate leaves one surviving spouse and children. So if this is the case, again, the personal and the household effects will go to the wife or the husband, widow or widower. We are talking of the spouse. It's 2-way. So a life interest in the whole residual of the intestate, if the surviving spouse is a widow, this interest ceases upon, again, her remarriage to any other person to avoid being abused. So on the death of the surviving spouse or on her remarriage, if she is a widow, the residual of the net intestate again is equally divided among the children alive at the moment of the death or remarriage of the surviving spouse. Can I take you back while we were talking of the Article 39? If you recall, Biwott had 3 wives. Biwott did not share anything to the wives. And there is a reason for that. He shared the wealth to the children, who are 2. We have Rita Biwott and we have Rhoda Biwott, and said, the wealth that I've given them, if they so wish, they can share to the mother. Of course, the mothers had already taken the households, isn't it? So if I give the child the wealth, if they so wish, they can sustain the mother. Biwott was a billionaire. I want it to ring a bell. Why the law is behaving this way is to avoid the abuse. And then we have the last scenario. The intestate leaves several wives. This is supposed to be E. T or D, supposed to be E. A case where the intestate leaves several wives, married under any system of law that permits polygamy. For example, Muslim law, the Sharia law. So this is what will happen. His personal and household effects and the residual of the net intestate shall first be divided among the houses. Kindly note, the house means family unit comprising of wife, whether alive or dead, and their children. So that's what we are calling a house in law. So a house is not a building. In law, a house is wife and children. Whether the wife is alive or not alive, we are going to take that as a house. We have an example, let's see. So according to the number of children in each